It's like a CEO getting caught breaking company policy and then trying to fire the compliance department for pointing it out. Now imagine that CEO isn't running a company, he's running a country. And instead of HR, it's the federal judiciary. So here's the question that no one in Washington seems willing to answer out loud. What happens when the President of the United States decides the law is optional? Because this, what you're about to see, is not a normal political dispute. It is not routine judicial review, and it is definitely not just another headline cycle. This is a live stress test of the American constitutional system centered on one name, Donald Trump. This is the moment where executive power runs straight into a wall called the rule of law, and instead of stopping, it starts pushing. And the push is getting harder. Let's establish the frame immediately, because the framing matters more than anything that comes after. This is not a policy disagreement. This is not Republicans versus Democrats. This is not even about ideology. This is about whether a sitting president can declare wartime powers when there is no war, act on that declaration, get blocked by a federal judge, and then respond not by complying, but by escalating. That's the sequence. Not speculation, not interpretation. Sequence. Statement, action, judicial block, retaliation. And the retaliation is where the story turns. Because when Donald Trump is challenged in court, he doesn't just argue the law, he attacks the referee. He calls federal judges criminals. He demands consequences, not for breaking the law, but for enforcing it. Pause on that. A president under legal scrutiny is not disputing a ruling, he is delegitimizing the entire system that issued it. That is not normal friction between branches. That is structural pressure. Now let's talk about what was actually said and what was not said. What was said, I have wartime powers. What was not said, where the war is, who authorized it, or under what statutory framework those powers are triggered. What was said, judges are criminals. What was not said, any legal basis for that accusation, no statute, no evidence, no process. What was said, Congress should act against judges. What was not said, how that doesn't collapse the separation of powers entirely. This is where we shift into prosecutorial mode. Because when you strip away the rhetoric, what you're left with is a pattern, and patterns are what prosecutors build cases on. Fact 1. Multiple federal courts have blocked major executive actions tied to these so-called emergency or wartime authorities. Fact 2. Those rulings are not isolated. They are consistent across jurisdictions, across judges, across ideological lines. Fact 3. Instead of narrowing the legal argument, the response escalates into public attacks on the judiciary itself. Now here's the contradiction. If the legal argument is strong, you defend it in court. If the legal argument is weak, you attack the court. So, which one are we looking at here? Because this is no longer about one ruling. This is about a president testing how far he can stretch power before something breaks. And the system, slow, procedural, deliberate, is pushing back in the only way it knows how. Injunctions, opinions, warnings, quiet tools. But they're starting to stack. And when those tools start stacking, pressure builds. Pressure builds. And when pressure builds inside a closed system, it doesn't just sit there, it looks for a fracture point. Right now, that fracture point is not theoretical. It has a name, a courtroom, and a paper trail. Because while Donald Trump is publicly attacking judges, the judiciary is doing something far more dangerous to his position. It is documenting him. Not with rhetoric, with rulings, with injunctions, with written opinions that don't disappear when the news cycle moves on. And the receipts are piling up. Let's put numbers on this because numbers strip away spin. At least 17 major policies, 17, have been blocked by federal district courts through nationwide injunctions. 17 separate moments where a judge reviewed an executive action and said, in plain legal language, no, you don't have that authority. Not once, not twice, 17 times. That's not coincidence. That's not partisan sabotage. That's a pattern of overreach meeting a consistent legal boundary. Now listen carefully to the logic chain because this is where the contradiction sharpens. If one court blocks you, you argue appeal. If multiple courts block you, you refine your legal theory. But if courts across the country, appointed by different presidents, confirmed by different senates, are all reaching the same conclusion, then the problem is not the courts. The problem is the action itself. And yet, instead of recalibrating, Donald Trump escalates. He doesn't narrow the scope. He doesn't adjust the legal justification. He widens the conflict. He reframes the judiciary as the enemy. He calls judges rogue. He labels them criminals. He suggests Congress should intervene against them. That is not legal defense. That is narrative warfare against the institution designed to check him. Now let's introduce another piece of evidence, because this is where the system itself starts reacting internally. A federal judge in Washington, James Boasberg, sends a warning, not to the public, but to fellow judges. The warning is simple, but it carries enormous weight. Be prepared for the possibility that the president may not follow court orders. Think about what that means. A sitting federal judge is not debating legal theory. He is anticipating noncompliance from the executive branch. That is not routine. That is not normal judicial caution. That is a signal that the system itself is bracing for impact. And again, look at what was said and what was not said. What was said, judges should prepare for a constitutional issue if orders are ignored. What was not said, any confidence that compliance is guaranteed. That silence matters, because in law, what you don't say often reveals more than what you do. Now, here's where the contradiction tightens into something harder to ignore. If the president respects the rule of law, then court orders are binding, even when inconvenient. If the president suggests those orders can be ignored, or attacks the legitimacy of the judges issuing them, then the system is no longer operating on shared assumptions. And without shared assumptions, enforcement becomes a question of power, not law. This is the escalation phase. Not louder headlines, not sharper tweets. Structural escalation. Because every blocked policy is not just a loss, it's a written record. Every judicial warning is not just commentary, it's a signal of risk. And every public attack on judges is not just rhetoric, it's evidence of intent. Evidence that, when stacked together, starts to look less like isolated conflict, and more like a case being built in real time. And when a case starts building in real time, the question is no longer whether something happened, it's whether the pattern can be ignored. Because at this point, the pattern is no longer subtle. It is visible, documented, and reinforced by a second parallel track that has nothing to do with executive power and everything to do with personal accountability. We're talking about the criminal case. Specifically, the ruling from Alvin Hellerstein, who looked at yet another attempt by Donald Trump to revisit his conviction and shut it down with language that was not dramatic, not emotional, but devastating in its clarity. You've already had your trial. You've already had your appeals. This is not a second chance. It's repetition. That's the line. That's the boundary. And what makes that moment so critical is not just the rejection itself, but what it confirms. A sitting president operating under the weight of an existing criminal conviction, repeatedly attempting to reopen a case that the courts consider settled. Now connect that back to everything we've already established. On one side, you have executive actions being blocked 17 times because courts say the authority isn't there. On the other side, you have a criminal conviction being upheld because courts say the process has already run its course. Two different arenas, same conclusion. The system is holding its line, and yet the response remains the same. Escalate, attack, deflect. Instead of acknowledging the rulings, Donald Trump doubles down on the narrative that the system itself is corrupt, that judges are politically motivated, that adverse decisions are illegitimate. But here's where the logic breaks under its own weight. If every unfavorable ruling is corrupt, then what standard is left? If every judge who disagrees is biased, then what does impartiality even mean? At some point, the claim stops being an argument and starts becoming an escape hatch, one that allows any outcome to be dismissed without evidence. This is where we shift from legal conflict to moral pressure. Because behind every injunction, behind every ruling, behind every rejected appeal, there are real-world consequences that don't show up in legal briefs. When policies are blocked, it's not abstract. It affects immigration enforcement, economic decisions, environmental protections. When courts are attacked, it's not theoretical. It chips away at public trust in whether the law means anything at all. And when a president signals that court orders might not be followed, it doesn't just challenge a ruling, it challenges the idea that rules apply equally. Picture it in everyday terms. If a business owner ignores a court order, there are consequences. If an individual ignores a court order, there are consequences. But if a president signals he might ignore a court order and frames the judges as the problem, what mechanism is left to enforce compliance? That's not a rhetorical question. That's the pressure point of the entire system. Because the Constitution doesn't enforce itself. It relies on a shared agreement that rulings matter, that limits exist, that power has boundaries. And once that agreement starts to crack, the system doesn't fail all at once. It erodes. Quietly, gradually, then suddenly. So now we're no longer looking at isolated legal defeats or political messaging. We're looking at a convergence, executive overreach, judicial resistance, criminal accountability, public delegitimization of the courts, all moving at the same time, all pointing to the same underlying question. Not whether one ruling was right or wrong, but whether the structure holding all of this together can withstand the pressure being applied to it. And when a structure is pushed from every direction at once, it doesn't collapse because of one blow, it collapses because the pressure never stops. That's where we are now, not at the beginning of a dispute, not in the middle of a routine legal fight, but at the edge of something far more consequential, a system being tested by the very person sworn to operate within it. Because when you line up the facts, 17 blocked policies, repeated judicial warnings, a standing criminal conviction, and a sustained campaign to discredit the courts, you're no longer looking at noise. You're looking at a trajectory that points in one direction, a direct collision between presidential power and constitutional limits. And here's the part that cannot be softened, cannot be spun, and should not be ignored. When Donald Trump calls judges criminals, when he suggests Congress should act against them, when he signals that rulings may not be respected, he is not just reacting to legal setbacks, he is redefining the relationship between power and law, not negotiating with it, redefining it. Now step back and look at the moral contrast, because this is where the abstract becomes real. On one side, you have institutions, courts, judges, written opinions, slow, procedural, bound by precedent, accountable to process. On the other side, you have a single individual with the power to command, to declare, to mobilize public opinion in real time. One side moves deliberately, the other moves instantly. One side explains its decisions in pages of legal reasoning. The other reduces those decisions to a single word: illegitimate. That imbalance matters, because when trust in the slower system erodes, the faster voice fills the vacuum. And that vacuum doesn't stay empty for long. It gets filled by doubt. Doubt about whether courts are fair, doubt about whether rulings matter, doubt about whether the law applies equally or only when it's convenient. This is no longer about party loyalty. It's no longer about policy wins or losses. This is about whether the average person watching all of this unfold still believes that if a court says no, the answer is actually no. Because if that belief disappears, enforcement doesn't just weaken, it becomes selective. And once enforcement becomes selective, the rule of law becomes optional. So here's the question that sits at the center of everything we've just laid out, and it's a question that doesn't go away no matter how many headlines shift or narratives change. If a president can repeatedly push beyond legal limits, be stopped by the courts, and then turn around and attack the legitimacy of those courts without consequence, what exactly is left of the system that's supposed to check him? And more importantly, who does that system still protect? Does it protect the Constitution? Or does it only protect those who are willing to follow it? Because at some point, this stops being about Donald Trump as an individual. It becomes about the precedent being set in real time. The message being sent, not just to politicians, but to the public. That rules can be tested, that limits can be challenged, and that if you push hard enough, long enough, publicly enough, maybe those limits start to bend. Or maybe they break. If you've made it this far, you already understand this isn't just another political story. It's a question about the durability of the system itself. So I want to hear from you. Do you think the rule of law is holding, or just holding on? Drop your thoughts in the comments. Hit like if you want more breakdowns like this, share this with someone who still thinks this is just politics, and subscribe so you don't miss what comes next.